Forms of subordinate legislation. Meaning of subordinate legislation. All forms of legislative activity recognized by English law other than the supreme legislative power of Parliament are generally regarded as subordinate legislation. Such legislation derives its authority from the delegation of legislative power by Parliament to subordinate or inferior authorities. The authority exercising delegated legislative power remains subject to the control of the Supreme Legislature, and the rules or regulations made by it must remain with the limits of the authority delegated to it. The main forms of subordinate legislation are as follows. Colonial subordinate legislation. Its meaning, the powers of self government entrusted to colonies and other dependencies of the crown were subject to the control of the imperial parliament at Westminster. The Westminster Parliament could repeal, alter, or supersede colonial enactments. Such enactments therefore constituted an important form of subordinate legislation. However, for the purpose of the maxim delegatus non protest delegere, a colonial legislature was not regarded merely as a delegate of the imperial parliament. It could therefore delegate some of its legislative powers to other subordinate bodies, subject to the applicable legal limitations. Executive subordinate legislation. The primary function of the executive is to conduct the administrative affairs of the state. However, modern government requires the executive to exercise certain subordinate legislative powers delegated to it by Parliament. Parliament frequently authorizes government departments or administrative authorities to supplement statutory provisions by making detailed rules, regulations, orders, and notifications for carrying out the purposes of the parent act. Thus, executive subordinate legislation enables the administration to deal with technical and detailed matters which cannot conveniently be dealt with directly by Parliament. Judicial subordinate legislation. Certain delegated legislative powers are also possessed by the judiciary. Superior courts have the authority to make rules for regulating their own procedure and administration. This is known as judicial legislation in the true sense. Because the court make rules under authority granted by law for regulating their proceedings. It should be distinguished from the creation or development of law by courts through judicial precedent. Judicial precedent is a method by which courts develop legal principles which deciding cases, whereas judicial subordinate legislation consists of formal rules made by courts for regulating their procedure. Municipal subordinate legislation. Municipal authorities are empowered by law to make rules for the regulation and administration of their respective local areas. The enactments made by municipal authorities under such statutory authority are generally known as bylaws. These bylaws constitute a form of subordinate legislation because municipal authorities can make them only within the limits of the powers granted to them by the legislature. Autonomous subordinate legislation. Not all subordinate legislation is made directly by the governmental departments or statutory authorities. In certain circumstances, the state recognizes the legislative authority of autonomous bodies and gives legal effect to the rules made by them. Such bodies may make rules, regulations, statutes, or bylaws by regulating their internal affairs and the activities under their control. Examples: a railway company may be authorized to make bylaws for regulating its undertakings. A university may make statutes and regulations governing its administration and the conduct of its members and students. A registered company may frame articles of association determining its constitution, internal management, and administration. Such rules derive their legal validity from the authority granted by law and remain subject to the limitation imposed by the parent law. Conclusion: subordinate legislation is an essential feature of modern administration because Parliament cannot practically deal with every technical, procedural, and administrative detail itself. Legislative power is therefore delegated to various authorities, including the executive, judiciary, municipal authorities, autonomous bodies. The principal forms of subordinate legislation are colonial, executive, judicial, municipal, and autonomous. Although these authorities exercise delegated legislative powers, they remain subject to the limits prescribed by the parent legislation and the control of the superior law-making authority.